extended family members after Brexit. Now that the Brexit has happened, there is confusion about what will be the fate of the extended family members and the extended family members who have not so far arrived in the UK. So some of them are here, haven't had their applications done. Some of them are not here at all so far. The European regulations somewhat would continue at least till the end of this year for another 11 months. And after that, those who have already been here would still continue to benefit. So there is a bit of a panic between those who are extended family members. Extended family members may have to clarify now means someone who is not a family member, that is, he is neither the spouse, married partner, son, daughter, parent, they are family members. Apart from that, everyone is an extended family member if they meet certain the definition of extended family member. The most common is a partner who is an unmarried partner but is in a durable relationship. Durable relationship means that the relationship should be considered as something which appears to be long term and it is not just like a boyfriend or girlfriend but much more than that, almost similar to that of a partner. Now, under the normal immigration regulations, the definition of partner is that they should be together for at least 2 years, living together in cohabitation for at least 2 years. That does not apply to the European uh, applicants. So, in the case of those who claim to be durable partners of European nationals, all they need to prove is that the relationship is durable. There is no definition of durable as such. What they need to prove is that it is not something very temporary or something which is not going to last long. It appears that it should last very long. Maybe if they are together for a year, they can still claim easily that they are in a durable relationship. Otherwise, there is no reason for a couple to live together for a year continuously without any uh, break for 1 year. Similarly, sometimes they have a child together. If there is a child together, regardless of the length of cohabitation, it is easy to explain that this is a durable partnership. Now, after the Brexit, the extended family members will continue to be governed by the same principles as before the 31st of January. If someone is an extended family member, he would either be, as I said, most commonly an unmarried partner in durable relationship, or it can be siblings, brothers and sisters. It can be aunts, uncles, first cousins, nieces, nephews. So the definition is somewhat what we derive from a Home Office guidance on extended family members. Otherwise, the European directive doesn't exactly specify who is an extended family member, except for the durable relationship partner. That is something which the regulations and the directive do provide for. There's another issue with the extended family members, which is that they do not get an automatic right of residence in the UK. While a family member does get automatic right the moment they are a family member, like if someone marries a European national who is exercising treaty rights in the UK, that non-EEA national immediately becomes entitled to live in the UK and work in the UK without having made an application. The application is only a confirmation of the right. It is just a certification from the government that yes, this person is eligible to work and live in the UK. A family member gets the right of residence and the right to work in the UK automatically. The moment he or she becomes a family member, like by way of a marriage, they become entitled to all the rights. The residence card or residence permit or residence certificate is only a confirmation of right which already exists. These rights are not contingent upon the government putting a seal on it. No, they are already there. The time for the permanent residence, the 5 years residence period, starts from the time when someone becomes uh, a family member. Like if someone marries someone but obtains a card after 1 year, so they will still be able to apply for permanent residence, or rather get a confirmation of their permanent residence right after 4 years of the issue of the card. That is 5 years from the date of marriage, and not 5 years from the date of issue of the residence card. However, in case of extended family members, this is not an automatic right. This is something which the government has to grant unless they accept, they do not become family members of the European nationals. So that's why these are not automatic rights. These are something which has to be granted. Unless these are granted, the 5 years period does not start. So in cases of extended family members like unmarried partners, their 5 years does not continue if the relationship breaks down. There is no retained right of residence even for these extended family members. There is another issue with the extended family members is that sometimes when they make an application and they do not provide all the evidence, or the evidence is not convincing enough, and then they make another application seeking to provide more evidence or the deficient evidence. And if the Home Office, while considering the second application or maybe third or fourth application, if they say this is a repeat application, or this application is not materially different from the previous one and it is just a misuse of the process, so they can certify it as a repeat application, in which case there is no right of appeal. So the extended family members have to do their applications very well. So the first application should have all the information, all the documentary evidence to prove that they are really extended family members. Like if someone wants to bring in his nephew, so it's not enough to say that he is my nephew. No, if there are birth certificates provided, that also does not necessarily mean that they are related as claimed. They have to provide the birth certificates, marriage certificates, and things like that as a chain. Like the nephew would have to provide not only his own birth certificate to show that he is the son of this lady, but also the marriage certificate and also the birth certificate of the mother and of the European national, to show that they are brothers and sisters. Only then it will be apparent that this boy, who's the nephew, is the son of a woman who is the sister of a European national. So the full chain is required. So the documentation requirements have to be met as promptly as possible. It should be done in the first application, or if they get a right of appeal, they should do their appeal very well. Otherwise, they can have a block on future applications, and then the matter is gone. All they can then do is go into judicial review, and in the judicial review, it's a very limited scope. If the judge finds that the decision of the Home Office was not unreasonable, it may be wrong, but not unreasonable in the circumstances, then the matter ends. The judge can't say it, they may provide more evidence. No, the judicial review cannot take notice of any possible further evidence to prove the case. So the only important thing which I wanted to emphasize was that in the case of extended family members, the applications should be complete with all the relevant evidence. Thank you very much.